Hi, this is Lou Pulsford to give you a brief summary of what intellectual property or IP is. If you have anything to do with game design, you'll have seen this term IP bandied about. Now, I have to say I am not a lawyer, but I have read a lot about this. I've listened to lawyers talk about this many times. My first game was published about 35 years ago. I've written lots of magazine articles. Recently I had a book about game design published by McFarland. So I have a good idea of what I'm talking about. Unlike many commenters on the internet, there's a lot of misinformation on the internet. But nothing here is new. I'm just reporting what is for those who don't know. Any story, game, film, dance, music, painting, sculpture, invention, any creative work involving the mind is intellectual property or IP. In the last 100 to 200 years, nations have passed laws to enable creators to benefit from their creation so they can support themselves and can continue to create. It's in the self-interest of the nations. Prior to these laws, there was no reason why somebody with money couldn't appropriate someone else's intellectual property, their invention or whatever, and make money on it without paying the inventor a dime. For example, when Shakespeare's plays were published, the publisher then owned them, not Shakespeare, which is one reason why he kept them more or less secret and only had them in little bits that he'd give to the individual actors, which is why we're not sure about the exact text of some of Shakespeare's plays, or even whether some plays were written by Shakespeare or someone else, because it was common at that time for people to appropriate the name of a well-known author such as Shakespeare in the hopes that they would sell more of their published play. So, IP law is good, and there are several kinds of protection. And this is true in the United States, is what I'm talking about, but it's true in many other countries as well. The first thing to say, and this comes as a shock to some people, in general, game ideas cannot be protected. If you look on the World Wide Web, you can find a dozen clones of Risk. They're not called Risk because that's trademarked. They don't have the actual text of the rules of Risk. The rules are rewritten because the actual text of the rules is copyrighted. But the game plays exactly the same way, and it's perfectly legal. Because game ideas cannot be protected. So, the first and most common protection is copyright. It's easy to obtain, but it's not very effective. It now expires 70 years after an author's death. We also have trademarks and service marks, which seem in many ways to be more effective. And there's both common law and registered trademarks. They don't expire as long as they're in use. Then we have patents. Patents are supposed to be for an actual product, an individual expression of an idea. Although nowadays often that's not the case. Patents are almost never used for games that are actually published. There are lots and lots of patents that are ridiculous, where somebody has wasted a lot of money, but those games never see the light of day. Patents are very expensive and they're quite time limited. It varies a little bit, but it's in the range of 20 years, not very long. Then there are trade secrets and trade dress. Trade dress, I'll just briefly say, can happen when, say, you have software that looks so much like somebody else's software that it becomes a subject for a copyright violation, even though it's not a technical copyright violation, and this is becoming more and more common as time passes. So briefly, copyright is automatic when you create something. But if you want to sue for damages, then you've got to register the copyright, which is about $35. Common law trademark serves for many purposes. That's the TM after the name of a game, for example. But the registered trademark, which costs maybe $350, is more effective, and that's the R in a circle. But the common law trademark is much more common because it doesn't cost anything. But when you trademark something, it's got to be something that's actually in the marketplace. You can't trademark something that you're going to put into the marketplace. It has to be in the marketplace in order to be trademarked. And if it is no longer in the marketplace, then the trademark, the common law one, will expire. The registered one has a time limitation, and then you can renew it. There are other things that are rarely used, and one of them is patents, because they're very chancy, they're very expensive, $3,000 to $10,000 just to get one registered, and then there's a lot more that you have to pay as time goes on. And that doesn't count the cost of enforcing it in the courts. Also, about 2/3 of patents are invalidated when they come to court. Unfortunately, the patent office self-funds. They don't get money from the government, at least in the United States. So they award lots of patents that will fail, but they'll get paid for those patents, and that's how they support themselves. Now, it has to be said, patents work great for drug companies. That's how they can sell $1,000 drugs, because they get a monopoly for the time that the patent is valid. But you almost never see a patent for a published game. Trade secrets rarely come into these matters. Frequently that involves someone stealing information from someone else, or someone has worked for a company and then they go to another company and they tell the second company about what the first company is doing. Now, what about licensed properties? In other words, using somebody's movie or comic or book in order to make a game. Well, just say no to that. It's much too expensive. There are people who successfully do it. Fantasy Flight Games licenses lots of properties, but they're also a very large publishing company in tabletop game terms. The big video game companies license properties frequently, but they have a lot of money. Do you have a lot of money? Often, the amount of money that the IP owner can get from licensing a property, especially for a board game, is just not enough to bother with. Just the processing and so on, it's not enough to bother with. Now, the closest I ever came to a licensed property is Fantasy Flight's Doom game, because once at some point they sent me, intending to send me Britannia royalties, they sent me the royalties for the Doom game to the company that owned the Doom property. And I'll have to say that check was a lot bigger than my check. But it wasn't even 4 figures. It wasn't all that much money. Now again, big video games involve a lot more money. But anybody listening to this is probably not got that kind of money. There are lots of myths surrounding intellectual property. One myth is if you don't make money from a copyright violation, it's okay. And that's not true at all. It's still a copyright violation. And violating a copyright or trademark is a criminal offense. Violating a patent is only a civil offense. That is, it has to be settled in court. The government is not going to send police to arrest the people who you say are violating your patent. Whereas you might, in a few cases, be able to convince them to arrest somebody who's violating your copyright or trademark. Another myth is that you can mail a game to yourself and in an envelope and get the date stamped on it by the post office, and that proves something. It doesn't prove anything at all. Not a single thing. It's too easy to tamper with, among other things. And anyway, you now have copyright as soon as you make something, but you have to register it to obtain punitive damages, and also if you register it, you have proof that you have actually made it at a particular time, or you've made it by a particular time. Now, what about non-disclosure agreements? Non-disclosure agreements are almost never used between a designer and a publisher. Publishers, as soon as they hear a designer say he wants them to sign a non-disclosure agreement, they lose interest in him because they know he doesn't have a clue, or she. You are pretty much at the mercy of publishers. In fact, many publishers will require a designer to sign a release statement before accepting any submission. And that release statement essentially says, we may have something like this in the works, or get something like this from someone else, so you can't sue us if we come out with something very much like your game. And I'll have more to say about these topics in individual talks.